Good afternoon, everyone. It's a great pleasure to welcome you to this second episode of the Center for Climate Change, Energy and Environmental Law seminar series on litigation trends in the climate emergency. I'm Annalisa Savaresi. I am Associate Professor in International Environmental Law at the University of Eastern Finland at the Center, and it's a great pleasure to convene this series together with my colleague Kaisa Huta, who is here in the audience today. As you may know, if you joined us last week, this is part of a series that we have organized in order to share the research that we do at the Center. And in this regard, as we like to say, we are in the middle of nowhere at UEF. We are based in Eastern Finland, and we have a very large group of researchers specialized in environmental, climate, and energy law. There is, in fact, almost 70 of us. I think it's one of the largest centers in the world. And this is why we are in the middle of nowhere. With Kaisa, we have organized this series on climate litigation because this is a topic of great interest. It's also an opportunity to showcase work that we have led at the Center on Climate Change Litigation that's based on human rights. There's a special issue of the Journal of Human Rights and the Environment that is in the process of being published as we speak. And this webinar series seizes the opportunity to showcase some of the contributions to that journal. Last week, we heard from Joanna Setzer from the London School of Economics, who presented the paper on global trends in climate litigation and the coming of just transition litigation, which is a new concept that Joanna and I formulated in that paper. Today, we have a great pleasure to have with us folks that really need no introduction. We have Lucy Maxwell, Sara Mead, and Dennis van Berkel from Urgenda Foundation. The Urgenda Foundation has heralded the most important climate victories in courts so far that have influenced so many other cases that have been litigated elsewhere. So before I give them the floor, I would like just to explain how we proceed. If you were not with us last week, the way this webinar will work is that our presenters will introduce their paper. They will talk for about half an hour. You're very welcome to type your questions in the chat. I will be moderating the debate after the presentation. So I will try and be as interactive as possible, but when we have many questions, I will try and summarize and pose questions to our speakers so that we try and answer as many of the questions as possible. This webinar is recorded, so you have to be on best behavior. But Kaisa is, of course, keeping an eye and making sure that you are all muted and keeping your cameras off unless you're given the floor to ask your questions. So without further ado and chatter from me, I'll give the floor to our distinguished speakers. Please, the floor is yours. Thank you so much for joining us today.
Thank you, Annalisa, and thank you, Kaisa, for having us and organizing this event. We're really happy to be able to present this paper, which is a culmination of the work that we've done over the past years. And that's in the context of the Climate Litigation Network, a network that we set up in response to this wave of litigation that was really pushed a lot by the Urgenda judgment, which came out in 2015. And I will start with a little bit of context and of what the type of cases that we're commenting on, why do we have these types of cases, why are they important, and then I'll hand over to Sara and Lucy to really dig into the lessons that we've learned in the past years and that we've presented in this paper. So the broader context really is, it's obviously the climate crisis and the massively inadequate responses of particularly governments in response to this climate crisis. And what's behind this, that there is a global governance system. We have the UNFCCC, and we now also have the Paris Agreement, a global climate governance system, which is massively failing. And one of the things that this system is really failing at is to hold governments to account to whether what they are doing or what they say is necessary, and whether they are really doing what is necessary in order to achieve the goals that they say themselves are necessary to achieve. Because under the during the COP meetings that countries have every year, there's a recognition of the danger of climate change. There are calls on states to do more. There's a recognition of what needs to be done in rough terms, but there's basically no enforcement system. So what these cases really are, these climate litigation cases that we are now discussing, what we call systemic climate litigation cases, because they address at the systemic level what countries need to be doing in order to fulfill their obligations to achieve the 1.5 temperature target of the Paris Agreement. So it's not about implementation of existing laws, because if you look at all the existing sort of more narrower laws, energy laws, etc., environmental laws, they don't add up. But these types of cases really address the systemic responsibilities of the states. Now, we've had lots of cases being filed, and there are also, after the Urgenda judgment, there we've also had a whole width of judgments, and there's a really, and what we can see now is that there's a body of judgments which have by and large followed what the Urgenda court did, and that there are in finding that there are duties on the state to reduce its emissions, and that we can take lessons from these judgments, specifically for cases that are still up before the courts, but also future cases, because what we also see, if you look at the entire width of the cases, that there are challenges that need to be tackled. And the most important challenge of that is how exactly, and that's at the core of our paper and the core of what will be at the core of this presentation, how exactly can a court actually decide whether a government policy is lawful or unlawful, whether it's enough or not enough, and when does this legal duty arise? Because that particularly has been a question that some courts have indicated they found difficult, and some cases have been also lost on addressing this question, because in short, courts found that, well, this is a policy question that we can't really answer. There aren't any real legal or scientific standards that are available in order to answer this question. Well, the conclusion, to get to the very end, or actually, what is the core of our paper, is, well, there actually are. There are standards in law and in science that litigants and courts can use to allow courts on safe grounds to determine and decide on the sufficiency of government ambitions. And with that said, I will now hand over to Sara to get us into what are kind of like the main lessons coming out of those of the judgments I just described.
Wonderful, thank you, Dennis. So I'm going to start by looking back a little bit. So what we sort of learned from looking at these cases that Dennis has been referring to, and then I'll pull out a couple of elements of the court's inquiry that we think are really helpful for future cases as well, because that's really what we're trying to keep our sights on, where this litigation is going. And then I'll hand over to Lucy, who will pull out and spend more time discussing the standards that we've identified as useful for litigants and judges in future, the next generation of Urgenda-style cases, as we call it. So for this paper, as Dennis said, we scanned all the systemic mitigation cases that, at least that we're familiar with, which is around 40 or so cases that have been filed, and fewer that have been decided. But we looked at them all, and I'd like to highlight three key findings. So firstly, we found that generally speaking, courts are willing to hear these cases on the merits. So with some exceptions, primarily in North America, so you may be familiar with the Juliana case in the States and a couple of cases in Canada. Most courts are willing to consider that these cases are justiciable. So we saw that in cases in the Netherlands, so obviously the Urgenda case, Germany, so German family farmers and Neubauer, but then also Belgium, Canada, Colombia, France, Ireland, Nepal. All of courts in all of those jurisdictions have proceeded to hear claims in systemic mitigation cases on the merits. Among the reasons given by courts to hear these cases on the merits is the necessity of judicial scrutiny of executive and legislative conduct, in particular where rights are involved, and a lot of these cases are rights-based cases. The second thing that we found looking at the judgments in these cases is that many courts have found that states have a legal duty to mitigate or address climate change by undertaking mitigation efforts. And looking specifically at human rights and torts-based cases, they have formulated this duty in a range of different ways. But for instance, the German Federal Court in Neubauer determined that the state's duty of protection of fundamental rights includes the duty to protect life and health against the risks posed by climate change. So we also saw that obviously in Urgenda and various other cases. And despite states in almost all of these cases raising the drop in the ocean defense, so that's arguing that we only contribute a small amount of, we only contribute, negligibly to the global emissions, courts have almost always rejected that defense. And so they accept that even though climate change is a global problem that one state, be it Netherlands, Germany, or Colombia, can't solve alone, the state still has a duty to undertake mitigation efforts in light of climate change. And while these are really important building blocks, our third finding, and Dennis sort of mentioned it earlier, was that courts are more divided in relation to assessing the legality of the state's mitigation efforts. So a review of the decisions that we were looking at revealed a concern on the part of courts of a perceived lack of judicially manageable standards, or just, standards in general. So there was a sense on the part of courts that they couldn't inquire into what the state should be doing because there weren't standards against which they could assess that. And in the LaRose case, for instance, that was the reason also why the court struck out the case in the first instance. And they referred to the absence of judicially manageable standards. So this is where we focused our attention. And our aim was to show, as Dennis said, that there exist these standards. Before turning to Lucy, who's going to go into what those standards are, we also noticed a couple of really useful elements of the court's inquiry, which we think can also help cases going forward. And the first one is that in these cases where courts, so for instance, in Urgenda and Neubauer, where courts did actually engage with looking at what the state should be doing when it comes to mitigation, what courts were mostly interested in, those courts were interested in the minimum standard, and we refer to that as the minimum standard of reasonableness. In none of the cases that we studied for this paper did courts determine the precise scope of what the state should be doing or how they should be engaging or how they should be achieving their mitigation measures. Rather, they tended to confine themselves to looking at whether the state has achieved that minimum standard required to discharge its legal obligations. And now we're really focusing in on looking at these human rights and torts-based cases. So in these cases where there was an obligation on the state in light of the risk of climate change to undertake, reasonable and appropriate measures, or, measures that would be, the standard differs, but it's generally a reasonableness standard. The court was looking at, so in the Urgenda case, it said what was the absolute minimum for the state to be doing in terms of mitigation. And in Neubauer, the German Constitutional Court described the test as being whether the climate change mitigation provisions were manifestly unsuitable or completely inadequate to achieve the required protection goal. So we refer to this as the minimum reasonableness standard. So that's one element of the court's inquiry that we're looking at, in which we argue that there are an abundance of standards that courts can use to establish whether the court has met that, the state has met that standard. Secondly, we also see something akin to a duty to substantiate emerging in the jurisprudence. And that basically sees the court asking the question, can the state explain or substantiate or justify its mitigation measures and its efforts? And that was really critical in the Supreme Court decision in Urgenda. Basically, the court asked the state why the state considered that doing less than 25% by 2020 against 1990 levels would be sufficient, and or would be responsible more, given the threats of climate change. And given that the state could not give a reason why, or could not justify why anything less than that would be reasonable, the court ordered that it was necessary to reduce its emissions by 25%. And in the German Neubauer case, they adopted a similar approach, although perhaps less sort of obviously. The state basically couldn't explain how, despite having using up almost all of its carbon budget commensurate with its 2050 target by 2030. So basically, when the German Constitutional Court looked at what the Advisory Council had said was the budget that kind of was associated with that 2050 long-term target, given that the state couldn't explain how it would reach that target if it used up almost all that budget by 2030, the court, for that reason, that informed its decision to find that parts of the relevant act were unconstitutional and quashed it. So with those two sort of elements of the court's inquiry highlighted, I'm going to hand over to Lucy, who's going to now expand on the various concrete standards that we hope that can help litigants and judges going forward. So over to you, Lucy.
Great. So what I'll look at now is, if you can imagine the life cycle of a case, a systemic mitigation case, and that's one that challenges the state's overall efforts to mitigate climate change. If you imagine the life cycle of that case, what we've talked about is that courts around the world, when they've been adjudicating these cases, have established, as Sara said, that existing duties, primarily in tort and human rights, apply to climate change, that these cases are justiciable. What I'm going to look at is the most challenging stage of the case, which is, well, how does a court assess whether the mitigation efforts meet the legal obligation, which, as Sara has explained in tort and human rights, requires a minimum reasonableness standard. And that's well established in many jurisdictions. It's just applying that to the problem of climate change. So in some jurisdictions, this is called the breach stage, or the stage of determining whether the obligations have been violated. And it's here that some courts have proceeded to engage with this, but others have found it much more challenging. So we will look at the judgments. We've looked at the judgments of courts that have grappled with this question and the sources that they have drawn upon to substantiate what the state's obligation means, and then to assess whether the state's meeting that obligation. And what we see is two key bodies of sources that courts turn to, and roughly about 7 standards that arise from those sources that are used to interrogate states' mitigation efforts. And in essence, the inquiry is, what does reasonableness require in this context? Because the duty of care in a tort law context or in a positive obligation human rights context is an open norm. And we know courts over time apply that norm to the different circumstances of the harm in question. And the question is here, what is reasonableness in the context of climate mitigation? So I'll touch on those 7 standards, but firstly, there's 2 key sources that courts look at. It will be no surprise that those sources are international law, particularly on climate change, and best available climate science. So in terms of international law, we know that different jurisdictions have different approaches to how binding international law is. But it's very common that we've seen in cases in lots of different jurisdictions for the courts to refer to the UNFCCC, the Framework Convention on Climate Change, and the Paris Agreement to inform the content of the state's duty. And I'll touch on what that means in practice as I go through. And courts are also looking at principles of customary international law, the no harm principle in particular, that you can't contribute to transboundary harm arising from your territory. In terms of best available climate science, again, that's primarily the reports of the IPCC. And it's particularly important that the summary of those reports is approved by the states themselves. So they're a particularly potent body of evidence because the states are fully aware of their contents. But best available climate science also includes the UNEP Environment Programme, the emissions gap reports, and reports of national scientific institutes, which in the German case that Sara mentioned was very important, also in the Belgian systemic mitigation case. So what do these sources tell us in terms of the minimum standards for a state's mitigation efforts to prevent dangerous climate change? We formulated 7 standards, and some are more prominent in some cases than in others, but we see that national courts are engaging with each of them in a range of different jurisdictions. The first standard is the long-term temperature goal upon which a state's mitigation efforts are based. This is the first question that communities and individuals bringing cases will ask themselves, because the temperature goal that is adopted informs the remaining emission space globally within which the state can operate. And it's very clear, and communities have a lot of evidence to draw upon to say that that temperature goal must be no more than 1.5 degrees. And states themselves, we can see in the Glasgow Climate Pact just in November last year, have reaffirmed that that really is the danger line because we know the science regarding the impacts above 1.5 degrees. And national courts have begun to engage with this at quite a specific level regarding the temperature goal. So the Hague District Court in the Shell case affirmed that 1.5 degrees was the starting point for any mitigation efforts in that case of a company. And the Dutch Supreme Court and the Irish Supreme Court both indicated the scientific consensus around 1.5 degrees. So if a state is proposing to take efforts that are far off track for a 1.5 degree world, which many of them are, that's the beginning of an indication of an unreasonable approach and not in line with those human rights or tort obligations. The second standard relates to whether a state's contribution is in line with its fair share of the global mitigation effort. And this is a key question in almost every systemic mitigation case that's happening around the world. Now, you might ask, why is a question of fair share even appropriate for a court to consider? Well, the answer is that states themselves in the international climate change regime have expressly adopted commitments regarding the fair contribution to the global effort of climate change. In both the UNFCCC and the Paris Agreement, it says expressly that developed countries will take the lead in mitigation efforts. And further, all countries to those 2 treaties committed, again expressly, to adopt mitigation efforts in line with the principles of equity and common but differentiated responsibilities. And those legal principles have been affirmed time and again, every time the states meet in the COP on an annual basis. So there's clear legal recognition by states that these principles matter. But what does that mean in practice for an individual state? And how can a court engage with that question? Well, there's really now a few methods and a few indicators that courts can look at to assess this question. The most robust of that is the body of scientific literature that relates to so-called effort sharing. And that's the literature that divides the global carbon budget for a particular temperature goal, so 1.5 degrees in this case, between countries. And while there are a range of approaches for that division, there is a meta-analysis that can be done based on all the approaches used that provides a range of emissions reduction for a particular country. And in a recent prominent study by Professor Lavanya Rajamani at Oxford and colleagues at New Climate Institute, they've taken that range and they've ensured that it was consistent with international law, which the states themselves have committed to. And the very specific findings of that study is that developed countries must reach net negative emissions by 2030. So that is a source that courts can turn to and that litigants are already relying on to show that the state that they are challenging is far off track from that kind of level of emissions reduction that is needed if we're going to keep 1.5 degrees within sight. The Dutch courts were the first courts to engage with effort sharing literature. Then it was looking at the body of literature that was in the IPCC's report from 2007. And what's really important is the Dutch courts acknowledged that this literature does not provide, and I quote, cut and dried answers for a particular state's emissions reductions, but it's a reasoned proposal and it can form the basis of a state's duty. We see the German Constitutional Court in the Neubauer case also engaging with the question of fair share. It is not shying away just because it's complex. It acknowledges that a state cannot adopt, and I quote, an arbitrary approach to its own fair share, that there are standards to engage with. Finally, if a court is unwilling to engage with the effort sharing literature, the global average of emissions reductions that are required for 1.5 degrees is a final minimum benchmark that litigants can point to. It, of course, doesn't take into account any additional responsibilities of developed countries, but it says, and AR6 tells us, that global average for 1.5 degree is a reduction of about half on 1990 levels by 2030. So if the developed country in question is nowhere near that global average, that's a further indicator of failing to adopt a reasonable approach to climate mitigation. So we've covered 2 indicators, and they are the very significant ones. There are 5 more, and I have only about 5 minutes, so I'll go quite quickly through them. But I'll group 3 of them together, and the German Constitutional Court was particularly instructive on these indicators. These ones are that a state's mitigation measures must have an explicit goal around carbon neutrality, that there must be consistency between a state's long-term emissions reduction target and their short-term target, and further that there needs to be progression in a state's mitigation ambition. And what was very interesting was that the German Constitutional Court articulated each of those elements, which find support in both climate science and, as we know, in the Paris Agreement. In terms of progression, there's a clear expectation in the Paris Agreement that a state's mitigation efforts should be increasing over time, and that carbon neutrality must be met in the second half of the century. And now we know that that needs to be as soon as possible if we're to keep 1.5 degrees within sight. And that for developed countries, if globally we're hitting net zero at 2050, developed countries in line with their additional responsibilities must be reaching carbon neutrality well before then. So those 3 standards, I think, are particularly important, and I'd encourage you to have a look at what the German Constitutional Court said about ambitious, lofty, long-term targets that are not supported with short-term action, because as Sara said, the court was particularly willing to scrutinise a state's failures in the short term to reduce emissions, which it could see would exhaust its entire carbon budget, leaving nothing left for future generations and resulting in huge restrictions on daily life. And they found that to be unconstitutional. So courts are really looking at this question. Okay, so the final 2 indicators. The 6th one is about a state's proposed use of negative emissions technology. This is natural and artificial mechanisms to extract emissions from the atmosphere once they are released. And we can see quite a lot of states, it's a very tempting prospect to not take radical emissions reductions in the short term, but propose to rely in the future on taking the emissions out of the atmosphere through technology that we hope to be developed. And what we have clearly from national courts is an expression of serious concern about states' proposed reliance on such technology. And if we're thinking about the reasonableness standard, national courts are saying, we are interrogating this and we're not convinced that it's a responsible approach to rely on that to a great extent in the long term. So the Dutch Supreme Court in Urgenda cited findings from the IPCC that, and I quote, there is no technology that allows negative emissions to take place on a sufficiently large scale, end quote, and that excessive reliance on such technology constitutes, quote, irresponsible risks, quote, and would run counter to the precautionary principle and thus not consistent with the state's human rights obligations to protect persons within its jurisdiction from the harm posed by climate change. And the Constitutional Court in Neubauer similarly expressed concerns that we just don't have evidence that the negative emissions technology can be implemented at scale. So the final and 7th indicator of whether a state is adopting reasonable and appropriate measures to mitigate climate change is whether the state has outlined in sufficient detail how it will reduce those emissions. public participation, access to information, and climate change education are central to the UNFCCC and the Paris Agreement. And there's a need to share information with the public about how goals are to be met. Otherwise, they really are just empty promises. And in Neubauer, the German Constitutional Court acknowledged the importance of transparency and clarity in mitigation measures and future plans, as did the Irish Supreme Court with respect to a statutory regime that required the government to specify how it would reach its long-term targets. So as we can see, there are a range of standards drawn from science and law that national courts have engaged with to interrogate states' mitigation measures in rights-based and tort-based mitigation cases. And really, we urge litigants to draw upon this body of standards and to put forward the case that there are real benchmarks against which a state's mitigation efforts can be assessed. It's not an area of whole discretion or one in which courts can't tread. So really look forward to the analysis and discussion that follows, and thanks for listening.
Thanks to you all for this great presentation. It's a paper of great depth and complexity. So if you've not read it already, Lucy and her colleagues have shared not only the link to the actual early electronic version of the paper, but also the freely accessible version on SSRN and the blog. So take a look. Please type your questions in the chat or raise your hand if you like to ask a question live. Once you get organized to do that, I thought I'd raise a couple of general questions for our speakers. If you allow me to summarize and hopefully not trivialize, your practice and your article deals with a specific kind of litigation, which is litigation that targets climate laws and policies that are not good enough. And in this regard, I think the determination of what is good enough is really very interesting and important part of your work. I wonder if you could elaborate a little bit on the specific role of human rights in determining this minimum standard. As you know, this is a bit of a hobby horse of mine, and it's indeed the running red line across the papers in the special issue. Urgenda relied in part on human rights. This became a prominent theme in the subsequent court decisions. So what is the role you think of human rights here, and can it be exploited better in future litigation? How do you see this now and in the cases that you looked at and in future?
I'm happy to give some initial thoughts on that. I think that human rights offers a number of, a human rights framework for these cases offers a number of benefits. One being that it places squarely before the court the impact on people and their livelihoods and their cultural rights and their way of life. And it makes climate change and what states do a matter of utter urgency and significance. So I think that's first and foremost. People are at the center and people are being affected right now and in the future. And secondly, it then enables courts to draw upon such a well-established body of jurisprudence. If we're talking the inter-American system, the African regional system on human rights, the European, national jurisprudence, we have sort of 40 or 50 years, if not more, of whether it's a negative obligation jurisprudence or much more common, the state's positive obligations to take measures where there's a foreseeable and serious risk of harm to human rights. So courts can be assured that this is operating within well-established legal norms, and it's just a matter of applying it to a new kind of problem. And I think that's really important. We saw in the Dutch case, extensive reference to the European Court of Human Rights existing environmental jurisprudence, which has responded to things like a gas explosion, a mudslide, flooding, all kinds of environmental disasters, and ones that the state has been aware of and has been on notice and has failed to take precautionary measures. And so I think that's really important. And the third benefit I think that a human rights law framing offers is that there is such commonality between those norms, between jurisdictions, that allows for this really rich dialogue between courts and between litigants in courts, as they can each build on each other's work. Yes, there are important differences in jurisdictions, but there is great learning to be had as courts are navigating this new area, to see how others have done it. And we can see that, you know, the number of courts that cite the Urgenda case or the Irish case or the German one, they're looking to each other, and they can draw strength from the analysis based on similar guarantees. So that would be a couple of thoughts there.
If I can add to that, Annalisa, to what Lucy has said there, I think one of the kind of like central roles that human rights can also play is that human rights as such have also been framed as a duty to, or a right to justification, and that relates to what Sara has said, sort of what we describe as a duty to substantiate. So under human rights law, it's also sort of well established that it is for a government to, in certain instances, explain that what it is doing and the specific measures it has taken are sufficient in relation to the threat that they, you know, to the potential harm that they are addressing. And I think that you know, that's a framework of human rights that is very helpful for these types of climate cases, particularly because what, you know, the main concern that these cases raise is you know, separation of powers, is what is exactly the role of courts in this? Are we asking the court to determine policies or not? And what we've seen in human rights jurisprudence is that courts look at, well, is there actually an effective regulatory system in place? Does that regulatory system comply with certain minimum standards of what you can see as sufficient and reasonable in relation to the harm? So these kind of like these two main concepts that Sara pointed out, those are very much kind of like drawn also from the larger human rights body of jurisprudence. One of the things where, you know, I think there's, you know, or we think there's still a lot of room for development from the human rights field and the human rights community is actually in the concretization of these standards. Because if you look at the standards that are, you know, kind of like the traditional human rights standards, then those do not necessarily answer the question and make it very concrete and provide us with very concrete standards of what a state must do. So, and that's also why in this paper we are mainly drawing from international law, more, you know, mostly international environmental law and best available science. And we think, I mean, that's what we would argue, that also in the context of human rights, those are the sources that the human, you know, that human rights in human rights adjudication should be drawn upon to further specify the specific human rights norms in relation to climate change. Because, you know, as with all of the fields that we are describing, human rights as such was never thought of, you know, was never written down with having climate threats in mind. So human rights field is also still very much developing, and you know, what is it exactly that the human rights norms mean in relation to these specific threats? And that's kind of like also where we came at with, okay, there are these open norms, how do we make them more concrete? And the standards, as we wrote, you know, as we presented them in this paper, is our sort of best attempt at what we think is the best way of making those standards concrete in the different legal contexts.
Many thanks, Dennis. I remind people that if you want to ask questions, just type them in the chat or raise your hand. I can keep this conversation going for sure. And you probably saw me nodding. I couldn't agree more. I think that Human rights law provides some useful hooks, but at the same time, we do need more concrete answers from human rights law. And we have a new special rapporteur on human rights and climate change that hopefully will provide those answers to us, because we really have a lot of scope to use the law more and better as we progress with the history of climate legislation. I can see Carlotta Garofalo has raised her hand. Carlotta, please feel free to ask your question.
Thank you very much. Can you hear me?
Yes, we can.
Okay. I would have a follow-up question to this human rights question. So I was wondering whether this minimum reasonableness standard that was, for example, applied in the Neubauer case might be considered as a violation actually of human rights of people living in developing countries, for example. So people living in countries that have a right to emit more because they have a right to develop, considering that this global average approach, for example, is distributing emissions equally across countries, or even a violation of human rights for people living in exposed countries, because this would not be enough to protect them. Thank you.
Thanks, Carlotta. Please, whoever wants to answer that.
Sorry, Carlotta, could you just, is your question specifically in relation to the 1.5 standard? Or I might have
it's more related to the global average approach that I think you consider as an application of the minimum reasonableness standard. Yeah.
I can maybe have a go at that, and then my colleagues can chime in. I think we're very clear, or we have tried to be clear in our paper, that we don't consider that standard to be consistent with international law, certainly not common but differentiated responsibilities and the principle of equity, but that it can be used in in a kind of specific circumstance to show that the state is not doing enough. So not to show what the state should be doing, but to show that the state isn't doing enough. So and sadly, it would serve that function in various different jurisdictions, because many developed countries are not even doing the global average. So if you simply wanted to have a standard to show that the state was not acting reasonably, you could simply point to the global average to say you've accepted in the Glasgow Climate Pact that this is the reduction required for the global average. And therefore, in the absence of reducing emissions, and that's now halving it by 2030, you are acting unreasonably. However, if you wanted to show what the state should be doing and to point to what an individual country should be doing, you would have to have recourse to the effort sharing methodology literature, which aggregates the findings of that literature to determine, as you're familiar with, a specific reduction rate required of that state. So we would agree with you, the global average doesn't set the minimum for a developed state, but it can still be a standard that can be used in systemic climate litigation. But Lucy and Dennis, feel free to chime in if you'd like to contribute to that.
Yeah, I've got two thoughts in addition to what Sara said, which is basically the core of how the relationship between these two standards that we, with regards to this fair share that we outlined. But I think a first reflection is that this climate litigation is a very much to say the least, a suboptimal way of addressing a problem. So we really see kind of like climate litigation has also been dubbed the second best of global climate governance. And it's really, because ideally we would have a global governance system where we would be dealing with this problem and where these issues would be dealt with at a international level, because that's really the only level where you could come to a really fair share distribution that complies with all, with international law principles such as common differentiated responsibility, and do justice to the rights of especially the developing world. However, we don't have that. So we're left with national courts applying the laws within their own jurisdiction. And one of the very suboptimal ways of things is that, well, you have these suboptimal standards, which are this minimum reasonableness standard, but also the impacts taken into account in such a case, in all of the cases that we've seen thus far, only relate to the impacts within the own jurisdiction. So within either the Netherlands, France, Germany, and most of the countries that have caused this problem are actually, many of them are in areas which are not that which are not that impacted in the first instance, which is at the core of the massive engraved injustice, which is climate change. But that's just the legal systems within which courts have to work. The second thought here is that especially courts are often, some jurisdictions are more progressive than other jurisdictions, but there are definitely jurisdictions where separation of powers and venturing into policy is something that that courts feel very anxious about. And in those jurisdictions, and that's especially why we presented this kind of like this global average as the really bare minimum, because we think that it goes beyond any reasonableness for a developed country to be doing less than what is the global average. So we don't see it as, indeed, as Sarah said, what needs to be done, but it could be a standard on the basis of which a court could decide that at least the current policies are not sufficient, and then send the government back to the drawing table and say, well, you come up with what the right target is, but I, as a court, can at the very least conclude here that what you're doing is not enough.
Yes, if I can just add something. Thank you very much for the answer, and I do understand the function of the minimum reasonableness standard, and yes, the function is to allow the courts at least to order the minimum. Maybe this is more of an academic issue that I find it interesting that there seems to be a bit of a contradiction, because this minimum is still based on human rights law, because the positive duty of the state is based on human rights law, but then there might still be a violation of human rights law if we consider it on an extraterritorial level. But maybe this is really not an issue in litigation. I would have a question also with regard to the effort sharing methodologies, but maybe I just leave it for later, and I leave the word to the others that have questions.
Well, make a note of that in the chat, and if we can, we get to that. Thank you so much for the good questions, Carlotta, much appreciated. Now we have Paula. Paula, please feel free to ask your question if you like.
Hi, so my question is related to, well, I think Dennis has touched a bit upon it, but regarding human rights, I mean, currently we have 2 pending cases before the European Court of Human Rights, and exactly noting the power that a human rights judgment of a court could have, because it's not only in the jurisdiction per se, but that then countries can rely on it. So, in your opinion, like these pending cases, will they play like an essential role in setting this minimum standard? And will this require a positive judgment, so and actually finding a violation, or could the court send some signal without it needing to find a human rights violation?
Big questions. Who wants to answer them?
Lucy, do you have thoughts on that?
Sure, yeah. So there's in fact 4 cases, at least as far as we know, that are before the European Court of Human Rights, climate cases. And I think what we see is just the diversity of those cases. They challenge different kinds of state action on climate change. They do that with respect to different affected groups. And so there's already quite a mosaic of the kinds of judgments you might receive. As we know, some of them are filed involving questions of extraterritorial jurisdiction, exhaustion of domestic remedies. There's a lot of different preliminary issues that will affect the cases in different ways. And so I think it's very hard to say what the results will be, but it's likely that there would, there may well be incremental developments in the cases that build on each other. So there may be recognition in some that the case is admissible and there is a positive obligation, but there's no violation, or other cases may fail at admissibility. And I think there's going to just be no single minimum standard that is expressed. It will be, I imagine, quite an incremental process of establishing how the European Convention can apply with respect to climate change. And so we'll really just have to watch this space. I think we don't know how it will play out, but national courts have already answered quite a lot of the key questions. I think that's our big message, is that, and on some of the most difficult questions like fair share, courts are engaging. We have the Dutch court, the German court, and the Dutch court in the Shell case also looked at effort sharing with respect to a company, or the emissions reductions required. So that pace, that ball is already moving, and those courts are referring to each other. And so whatever the European Court does, it will be highly relevant, but some of the difficult questions are already being addressed by national courts, is what I'd say.
No more comments on that? Then I will give the floor to Kajsa to ask her question. Kajsa, please.
Thanks. I'm going to use my privilege as an organizer to ask 2 questions. You mentioned on several instances that national courts are engaging with scientific facts and using them to justify their decisions. How do you feel, and this is probably a broader question that goes beyond just climate law, but also other goal-based legislation in environmental law, for example. But how do you feel, how prepared are national courts in interpreting scientific facts? So how fluent are they in the language of climate science, so to speak? And then my second question was a more academic question. Where do you see climate litigation scholarship going in the future, and what is it that legal scholarship and academia could do that we're not already doing in this area of research? Thanks.
Yeah,
So who wants to? Yes, please.
I'll give that one a go. I think initially it was perceived that climate science is too difficult for courts to engage with, and that was the general sense. But I mean, the short answer is that certain courts have actually, shown that they are able to deal with the science when presented to them in the right manner, and that's because we've seen these courts actually dealing with the difficult scientific questions. They are currently helped by looking at each other. It's very, for instance, very interesting that the Irish court quoted whole pieces of the judgments of the Dutch court for its climate findings. So you do see that these courts are looking at each other and also finding confidence in coming to kind of like the findings of at the very least the dangers of climate change. That's the most important one, and then also dealing with this question of fair share and the carbon budget. Another case where, for instance, the science of the carbon budget was dealt with in depth was in the French case, which we haven't mentioned during our presentation, but in France, basically the plaintiffs were stating that the intermediary targets set by the French government were not met. And the response of the French government was, well, we still have time to meet our 2030 target. We're not at 2030 yet, so we can still reduce at a later point in time. And the court said, well, but that's not really what matters in climate science. What matters is cumulative emissions. There is a budget, and what really matters is how much you emit over the entire course. And if you have emitted too much in one year, you'll need to compensate in the next year. So there you see that the court was able to properly engage with those facts. There are courts, however, that are kind of failing to see that are not still are failing to see sort of the irreversibility of the facts, the fact that if you don't act now and if you don't reduce now, that will have inevitable results somewhere into the future, and how these things relate to each other. So unfortunately, there have been judgments where at least our impression is that if the court would be better informed on climate science, that would have helped. But I think Sara is working on a very important project in that context, helping courts to decide on these cases. So Sara, maybe you can, spend a couple of words on that.
Yeah. So Dennis referred to what we call the transjudicial dialogue between judges in these types of cases. So where Urgenda started, it was a completely different landscape to where we are now. We now have quite a large body of jurisprudence that address, largely, often very much the same issues. And so we've got lots of cases that have addressed the issue of causation, attribution, the issue of separation of powers, so on. And so through the World Commission on Environmental Law, we're working with various experts to produce a judicial handbook, which looks at the emerging best practice from the jurisprudence on those various issues, and to bring to the attention of courts that are facing these sorts of difficult questions, how other courts have found a way through, because it is complicated, and very often a judge who's hearing a climate case is hearing it. It's the first climate case they're hearing, but it may even be the first, if we're looking at a systemic mitigation case, it may be the first systemic mitigation case being heard in that jurisdiction. And so there is a lack of precedents that they can draw on. So there are a lot of efforts that are going on to help judges sort of navigate this new territory. And we see the existing body of jurisprudence to provide, a lot of lessons that can be learned. And I'll just move on to the second question that you had, Kaiser, as well. And then Lucy can chime in, because it's something that we really spend we come up with a lot more questions, research questions, than we can ever answer. And we really enjoy having the opportunity to talk with the academic community to help us solve those problems or those questions. And one of them, of course, as we've already mentioned, is standards. We would love particularly the human rights community to put their heads together to think about the kinds of standards. It's all well and good saying we have these rights, and I think, and I'll just take a moment to refer the IPCC report's conclusion in their Working Group 2 report, which said that climate change is a threat to human well-being and planetary health. Any further delay, so on, will miss a brief and rapidly closing window of opportunity to secure a livable and sustainable future for all. So we have these human rights provisions, and we need to find a way, and we would love for the academic community to help us sort of find a way to give content and give some, some concrete standards to those provisions. Another one is we come up often, there are these human rights provisions like non-discrimination, where applied to the facts of climate change present just challenges. They are difficult to navigate. And I'll hand over to Lucy for that, because I think that's an area that she has also been spending some time on, and is something that we would like to see some more research on.
Thanks, Sara. Yeah, I think that's a very kind of discrete area where there's a need for more collaboration between practitioners and academics who've worked on equality and discrimination law, and those who are bringing climate cases that often turn on the disproportionate impacts of climate change on certain groups, both now, the current impacts affecting people with disabilities, older people, children, Indigenous peoples, people living in poverty, and also that the projected impact will disproportionately affect those groups. And so it's a form of indirect discrimination on protected grounds, and yet we haven't seen a lot of climate pleadings, engaging with that body of jurisprudence that we have from discrimination law. So that's a big one. In respect of child and youth-based cases, they're often saying the projected impacts that we experience is a form of discrimination because of when we were born, not because we're children right now, or it may be in addition to that, but it's because how old we will be in 2100. And that age birth cohort discrimination is something that we'd really like some more academic conceptual thinking done on, and then that, you know, work with lawyers that are bringing those cases. And finally, extraterritorial obligations. We've had some breakthroughs in terms of the German Constitutional Court last year, recognizing in a limited way the standing of people living outside of Germany in Bangladesh and Nepal, and the UN Committee on the Rights of the Child also recognizing extraterritorial jurisdiction. So what does that mean? How do we bring that in national cases, and more work on that? But they're just a couple of ideas. So yeah, lots more to be done.
Yeah, thank you so much.
More,
that's
Annalisa. Oh, sorry.
Okay, no, I was just gonna say that's a brilliant segue to the next and last webinar we have, which focuses on youth-led, the youth-led perspective. But sorry, Dennis, you still had a point to add.
No, I think I had a couple of other ideas, and that was in relation to two particular sectors, and that's aviation and shipping. If we're looking at the Paris Agreement, only covers what we call domestic emissions, so the emissions from territories of countries, and there have been huge in the context of international law, there have been huge arguments on, you know, to what extent can the EU regulate even aviation emissions if they want to charge or tax basically the entire emissions over the entire flight going from Europe to, for instance, the US. So basically, in short, aviation emissions and shipping emissions are often completely left out. We kind of like pretend that they don't exist. If you look at, for instance, the German judgment, and if you want to have some critique on that judgment, it looks at the carbon budget division, and it's the same for the Dutch case, and it divides the carbon budget purely among states, and then it pretends that shipping and aviation doesn't exist. It looks at the entire, because obviously there has to be some space for shipping and aviation also to emit. It is emitting, and it is increasingly emitting. So I think there are real questions on how can litigation address these types of mitigation, and is that with regards to should emissions from these sectors be attributed to countries, or alternatively, should legal obligations be called upon in relation to infrastructural decisions that relate to, for instance, expansions of airport or expansions of ports? Because I think, you know, principally, if a country has a human rights obligation with regards to, you know, the emissions of its territory, why would that obligation to take reasonable steps not expand to, for instance, its decision to expand an airfield? And I think that's a big area that needs, you know, a lot of thinking and further development. Another one, and I'll stick to two more that I think are sort of like new territories that still need to be explored. One is the extent to which countries should be allowed to use so-called carbon credits in their targets. I mean, there are some countries, for instance, Norway, but also other countries that on paper have very ambitious targets, but then huge amounts of that is carbon credits. In other words, emissions that are done somewhere else, and there's obviously a limit. I mean, there are several legal aspects to this, but there's a limit to how much emissions can be reduced on another territory. If every country does that, then there's nothing to be reduced anymore, and at a certain point, countries themselves will also have to reduce on their own territory. In fact, it's actually, the models already show that it's you know, we can't get there unless the large polluting countries do that straight away. So there will be arguments with relation to sort of the size of these carbon credits and how much you can call call upon these to fulfill your legal duty. I think that will be, there will be a lot of, even potential litigation on that in the future. And the flip side of that is, to what extent, I mean, that's actually the question turned upside down. As Lucy pointed out, the fair share, the literature, the scientific literature on fair share shows that developed countries should be reducing their emissions to 0 by 2030. And, very likely questions to be raised in court are then, how feasible is that? How feasible is it that they will be doing that on their own territory? And to what extent can they then, through, for instance, finance, fulfill those obligations in not on their own territory, but abroad? So it's basically the same question, but from two different sides. One from the sort of the obligation from these let's say human rights or tort norm, to what extent can you actually fulfill them abroad? And the other one is, well, is there a limit to how how far that goes, and is there a sort of how do you see the extent to which countries are actually allowed to do that abroad?
Thank you very much, everyone. That was a brilliant way to conclude. Given the audience, especially lots of young talents here, and I hope some of my students were taking notes. We are already working on some of these issues with Rosa. I hope you were listening attentively and keen, of course. But and some of my colleagues are already working on many of the issues that you have mentioned, which goes back to testify what I was saying earlier about us at CEO. So I thank you very much indeed for your rich presentation and paper. I'm so grateful you made time to be with us. Now, as Kajsa already mentioned, next week we'll have the last in the series where Margareta Wewerinke will be talking about children litigation, which is a very important and so far elusive area of litigation that has, however, a lot of promise. In the meantime, I thank you all again for participating today, especially our speakers, and I hope to see many of you next week. Thank you very much.